The Companies Act 1956. We need to focus on sections 20, 21 and 22 today to understand regarding the names of the company, which names are undesirable in the opinion of the central government. Subsection 1 of section 20 say, no company shall be registered by a name which is undesirable in the opinion of the central government. Which name is undesirable? Subsection 2 of section 20 brings us with following statements. Without prejudice to the generality of the foregoing power means what? The central government may feel a name may be undesirable. That is the power that it says no company shall be registered by a name which is undesirable in the opinion of the central government. This is the power in the name of the central government, in the opinion of the central government. A name may be undesirable. We may understand in following statements which name is undesirable. Without prejudice to the generality of foregoing power, a name which is identical with, or a name which is too nearly resembles with what? Which is identical with what? Identical with or resembles the name by which a company in existence has been previously registered is undesirable in the opinion of the central government. Second, a name which is identical with or nearly resembles a registered trademark or a trademark which is subject of an application for registration of any other person under Trademarks Act 1999 is also undesirable in the opinion of the central government. In about 2 instances, such a name may be deemed undesirable by the central government within the meaning of subsection 1. Subsection 3 of the section 20 say, the central government may, before deeming a name as undesirable under clause 2 of subsection 2, consult the registrar of trademarks. So, which sort of names are undesirable in the opinion of the central government? The provisions of section 20 enable us to understand. Let us go to section 21 and section 22 of the Companies Act 1956. Both sections, section 21 and section 22, are very interesting. Section 21 provides provisions regarding the change of name by company. What? Repeat. Change of name by company. Section 22 refers to rectification of name of company. Is it confusing? A little bit. See, first statement is change of name by company. Second statement is a rectification of name of company. How does it differ? This is what we are going to understand. First, change of name. Which one is called change of name? Which other is called rectification of name? We need to differentiate. Section 21, let us read it. Section 21, change of name by company. A company may change its name. How? By special resolution. This is number 1. By special resolution and with the approval of the central government signified in writing. How a company is going to change its name. Underline, change its name. A company may change its name by a special resolution and with the approval of the central government. See here, if a company wants to change its name, it requires special resolution. This is number 1. It requires special resolution. Number 2, it also requires special approval or the approval of the central government. How should it be? The approval should it be? The approval of the central government should be signified in writing. Signified in writing. This is what change of name by company. Section 22. Rectification of name of company. Underline and differentiate the statements. Change of name was referred by section 21. Section 22 refers to rectification of name of company. Where do we call a change as a rectification of name? Let us try to understand. If a company on its first registration, or on its registration by a new name is registered by a name through inadvertence or otherwise, in the opinion of the central government, is identical with or too nearly resembles the name by which a company in existence has been previously registered, whether under this act or any previous company's law. The first mentioned company. Second point, on an application by a registered proprietor of a trademark, or is, in the opinion of the central government, identical with or too nearly resembles a registered trademark of such proprietor under the Trademarks Act 1991. Such a company may, by ordinary resolution, underline ordinary resolution. When we are going to rectify a name of a company, we need ordinary resolution. In section 21, you may have come across, if a company wants to change its name, it requires special resolution. In section 22, when it wants to rectify its name, it requires ordinary resolution. Again, see, company may, by ordinary resolution and with the previous approval of the central government signified in writing, change its name or new name, and shall, if central government so directs within 12 months of its first registration or registration by its new name, as the case may be, or within 12 months of the commencement of this act, whichever is latter, by ordinary resolution with the previous approval of the central government signified in writing, change its name or new name within a period of 3 months from the date of direction, or such longer period as the central government may think fit to allow. In simple terminology, if a company wants to rectify its name, rectification may take place in two instances. Like if a name of a company after registration in advertence, such a name in the opinion of the central government is identical with or too nearly resembles the name by which a company in existence has been previously registered, may get rectified by ordinary resolution and with the previous approval of the central government signified in writing. By these two observations, a company may rectify its name. There is another instance. The central government may also direct within 12 months of its first registration or registration by its name, as the case may be, to get it rectify the name of a company as per the direction, or such longer period as the central government may think fit to allow, provided that no application under clause 2 made by a registered proprietor of a trademark after 5 years of coming to notice of registration of the company shall be considered by central government. Very interesting proviso. So if a name of a company resembles with a trademark, with a registered trademark, and such thing or such notice is given after passing 5 long years, such a request is not considered by central government. So this proviso to subsection 1 of section 22, let us repeat, provided that no application under class 2 made by a registered proprietor of a trademark after 5 years of coming to notice of registration of the company shall be considered by the central government. A name may be resembling with a registered trademark, but the application from the owner of the registered proprietor of trademark is made after passing 5 long years may not be considered by the central government and cannot proceed to get the name of a company rectified. Subsection 2 of section 22 say, if a company makes a default in complying with any direction given under clause B of subsection 1, the company and every officer who is in default shall be punishable with fine which may extend to 1000 rupees for every day during which the default continues. So we realize there is slight difference between section 21 and section 22. Change of name by company means it is a voluntary act. Here a company changes its name on its own by observing two procedures. One is having special resolution and with the approval of the central government signified in writing. So this process is identified as change of name. There is another process which section 22 refers. Here rectification of name of company. So rectification means it slightly differs with section 21, change of name of company. So rectification of name takes place if through inadvertence or otherwise a company on its first registration or on its registration by a new name is registered by a name which is in the opinion of the central government is identical with or too nearly resembles the name by which a company in existence has been previously registered, whether under this act or any previous company's law. The first mentioned company may rectify its name. How? By ordinary resolution and with the previous approval of the central government signified in writing. Rectify its name or its new name. Let us go to second point in subsection 1 of section 22. If through inadvertence or otherwise a company on its first registration or on its registration by a name, by a new name, is registered with a name which on an application by a registered proprietor of a trademark, underline, on an application by a registered proprietor of a trademark, which is in the opinion of the central government identical with or too nearly resembles a registered trademark of such proprietor under the Trademarks Act 1999, such company means a company which is having a name which is identical or which resembles with a name or with a registered trademark may by ordinary resolution and with previous approval of the central government signified in writing rectify its name. These are the 2 points subsection 1 of section 22 says us. Subsection 2 of section 22 comes with, if a company makes a default in complying with any direction given under clause B of subsection 1, the company and every officer who is in default shall be punishable with fine which may extend to 1000 rupees of every day during which the default continues. So if at all default take place, to observe the directions of the central government, every officer and also the company shall be punishable with fine which may extend to 1000 rupees for every day during which the default continues. So we are clear with section 21 and section 22. The statements change of name of company slightly differs from rectification of name of company.